Hello and welcome to this FMB webinar. My name is Hayley Lorimer, Director of Membership at the FMB, and I'm here today with Sarah Fox, the 500-word lawyer, and we are going to talk to you about the refreshed FMB suite of contracts and what's changed and why. So just a bit of housekeeping as we start. The webinar should take, I think, about 45 minutes, maybe something like that, depending how many questions you have for us. There's a Q&A box at the bottom of the screen. If you hover your mouse down there, it should pop up so that you can type any questions that occur to you during the webinar into that box. And Sarah and I, if there's anything I can answer, we'll do our best to answer those at the end of the session. You'll receive a follow-up email after the webinar, which will have a link to the recording. So if there's anything you miss or you want to go back and note anything, you'll be able to do that then. And we'll attach any links to any documents or information that we talk about during the webinar in there as well. The first thing to say about this is that it's not Building Safety Act training. We're not going to go into all the intricacies of the Building Safety Act, but we do already have a series of 5 webinars on the website for members that do that. So if you do want to go into more detail about the whole Building Safety Act and all the different aspects of it, those 5 webinars are there for you. We're just going to talk about the contracts, and we're going to help you to navigate the building safety law through the changes that we've made to the FMB contracts. And first of all, I wanted to tell you a little bit about the ethos behind the contracts. So since we've been working with Sarah for the past several years, the thinking behind what we're trying to do with these contracts is to make them really easy for you and your clients to use and to understand. They're also designed to be fair to you and your customer, as you would expect from a reputable organisation like the FMB, and concise because they only cover what's really needed, not every possible eventuality. So I think our contracts are now about 14 or 15 pages compared to a JCT, which I don't know, correct me if I'm wrong, Sarah, but I think that can run to like 80 pages or something like that. So they're much, much shorter than some of the contracts you might be familiar with. And they're free of charge for members to download from the website, and they help you to be compliant with the FMB Code of Conduct, which does say that members should use a written contract on each and every job for many and various reasons. So they're a much used benefit of membership, which is why we want to make them as useful and as up to date as we can. So why have we updated the contracts now? Well, first of all, because the Building Safety Act came along and created the new duty holder roles within it, which we thought it'd be helpful for members if those were clarified within the contracts. So that's what we've done. Also, we wanted to recognise the fact that across the 4 nations, aspects of the Building Safety Act are being applied differently. So we've consulted with lawyers in Scotland and Northern Ireland as well to make sure that they're as up to date as they can be for each of the 4 nations. We've improved the format as well. I think you'll agree, if you're already a user of the FMB contracts, that the addition of the front cover and lots of information about the FMB and about the contracts and how they can be used is a really helpful addition. And the format throughout the contracts has been improved also by adding in some flexible clauses as well. And some of those were at the request of members. We actually carried out a survey a year or 2 ago of members who used the contracts, and some of them made suggestions for improvements that could be put in there, and we've incorporated those wherever we can. So thank you if you were one of the members who responded to that survey. And just a little bit about the process that we went through for all this, just to reassure members that it's been very lengthy and careful process that we've gone through. So as well as consulting with Sarah to make changes in the light of the Building Safety Act, we've also consulted with another lawyer from Brown Jacobson, Gavin in London, who's made suggestions and improvements as well. And we've consulted with lawyers in Edinburgh and Belfast too, as well as the FMB staff team, in particular Simon. Thank you for all that detailed work on proofreading and coordinating with the designers and making sure that everything was consistent throughout and everything makes sense and is nothing missed from those contracts. And then finally, we did consult with a couple of experts from the Industry Competence Committee, which is part of the Building Safety Regulator, to get their view of things as well. And then finally, we've had designers working on them and the web team to get them onto the website ready for you to use. So that we haven't just sort of done this quickly. It's been quite a lengthy process, but we think that that gives you as members the reassurance that you're using something that will be really robust and helpful. And then I wanted to say a little bit about competence. So competence is a really important principle within the building safety legislation, and it's important for you as building contractors only to take on work which you're competent to carry out. So a lot of members have said to us, well, what does that mean in terms of what's competence? How is it defined? And that word there, SCEB, is quite an important one in this context. So that's an acronym for the four components that make up competence under the Act, which are skills, knowledge, experience, and behaviours. And we think that you have head start on this as FMB members because as far as behaviours are concerned, you're signed up to abide by our code of conduct, which talks about how you'll deal with clients in a fair way and with integrity. And you all have experience of carrying out similar projects, so you're able to demonstrate your competence in that way. So we've put together a really short form. It's 2 sides of A4. It's kind of a portfolio approach for you to be able to demonstrate competence. And what that enables you to do is to say, I know that I'm competent to carry out this particular piece of work because I've done some similar projects in the past, etc. So just going through that process is useful for you to have documented on file. It's useful for your clients to see that you're demonstrating your competence, and we think it'll set you apart from other contractors who might be tendering for projects, because if they're not FMB members, they won't have access to this document. They may have versions of it from elsewhere, but it may be useful to you. And there are 3 different versions for a principal contractor who's also acting as a principal designer, because some of our members do design and build projects, and also for you to use with your subcontractors to satisfy yourself that the subcontractors you're using have the competence to do the work as well. And at the moment, these are not mandatory documents for you to use, but they're helpful documents that you may want to use alongside the FMB contracts. And what I think we might do is send the PDF of one of these with the follow-up email so that you can have a look at this and give us your feedback on whether you think this will be useful, anything else you'd like to see, or anything that's not clear within that document. That would be really helpful for us. So that's the end of everything I wanted to say. I'll hand over to you now, Sarah. Thank you.
Thank you, Hayley. So, as you know, I've been involved with the FMB probably for about 8 years, and we started the process of kind of creating simple contracts. And I know they'd kind of been simplified in the past with the Plain English campaign and the Crystal Mark. But the reason we simplify is not just because we think it's, less paper or, less length. It's because we think that simple documents will give you confidence and your client's confidence in your skills, knowledge, experience and behaviours, but also that you know what the process of building is like, because most of them don't have much. A lot of the domestic clients certainly have very little experience of building except to see the car crash programmes that they might see on the telly. But we also want to safeguard your business because we want you to be in business for the long term, and we want to make sure that these contracts actually do what they need to do for you as members. But also we want to try and avoid the avoidable disputes. Now, I know that not every project is going to go swimmingly, and there will be some disputes that just simply can't be avoided. But where possible, we want to put you in the best possible position to continue your business. So the revised contracts, as Hayley has said, they've got this new front cover. They've got a bit of information inside the front cover. They've got a back cover. We've continued the theme of them being clear, concise and user-friendly. We've said, as Hayley has said, that they want to be consistent across the nations, but they're also consistently across the suite. So the fact that it's a small contract or a big contract or a domestic or a commercial or a subcontract, consistent wording, consistent format and all this kind of stuff. We've introduced a new date stamp effectively on the inside cover of the contract, so you can now check that you've got the most up-to-date version, because we're expecting member feedback as before to continually update these, but not update them sort of every month, but to update them in batches. So it'd be useful when we start that process. We've made sure the guidance notes are now more party neutral, so they don't say you and we, because we know that both you and your clients will need to read those guidance notes, and the text is now gender neutral. And there is some dynamic text, so I've highlighted on this front page where you can get the sort of information from the data that you put into the contract will ping onto the front page, so that it's really specific to a specific client. And I think that's a really useful tool, because what you want to do is when you pick up a contract is to know what project it is and who's involved quite quickly. So we have revised the contract, as Hayley said. Some of this was member feedback that you wanted a bit more flexibility in terms of things like personalising it. You wanted to have payment periods that might be less prescriptive. So we don't tell you what your payment period should be. You agree that with your client. There's reference to a deposit. I mean, it's not a deposit in the fact that they ever get it back, but we've got an advance payment or a down payment mechanism. We've got references to FMB or other insurance-backed guarantees, and a flexible defects period, because that may depend on the scale of the works as to whether or not you want that sort of period. So we've added some flexibility in. We've added more choice for the payment schedule, and we've got an additional note. So space to add other payment terms if needed. So it could be something very specific to this client. It could be something specific to the project. That's a place where you can add a bit more information if needed. Now, it's fair to say that although we have made these changes for the Building Safety Act, compliance with the Building Safety Act and the delegated legislation that comes under it, all those regulations, is mandatory. So even if you've not been using these new contracts, you should have been complying with the building safety laws and the building safety legislation. So what we've tried to do is to use these contracts to be really clear about what your duties are. The Act of Parliament itself is over 200 pages long, and all the regulations underneath it, it's more paperwork. So I'm not expecting you to read it. I did spend a day reading that Act, and it's a day I'm never going to get back. But what we've tried to do is distill what you need to know into these suite of contracts, so there's no kind of mismanaged expectations. And we're going to come back to competence and compliance a number of times. These contracts, in common with most of the suites that have been introduced since the Building Safety Act, is not for use with higher risk buildings. And those tend to be over, I think it's over 18 metres or 7 stories, have a residential element, or be a care home or a hospital. So if you get involved in those projects, there's other things you need to add into the equation, which these contracts don't do. So there's various bits of data that you need to fill in order to explain who the principal contractor is for the building regulations, what the competency requirements are. And you'll see on this bottom bit of the slide, it talks about skills, knowledge, experience and behaviours, the SCEB that Hayley was talking about earlier. One of the most important indicators of competence is your refusal to carry out work that you're not competent for. Now, we're not quite sure how that's going to play out in the sector, particularly when it comes to taking on design that other people have done. So there's still a little bit of jockeying for position, I think, in the sector about design responsibilities as separate to construction responsibilities. So it'll be interesting to see how, well, it might be interesting to see how it plays out, but there's still a little lack of sort of understanding how that's precisely going to play out in the next few months and years. We also need to add the information for the principal designer, the building regulations principal designer, not the same as the CDM principal designer, although maybe the same company, it's not the same duties. So I've highlighted on the left, and this shows the amendments we've made to bring in the main duties for a builder under the building safety legislation. And you can see it's pretty significant, the changes that we've made. So we've got things like planning, managing, monitoring and liaising with the project team, providing workers with instructions and information, reporting concerns about work. I think this is going to be a real important part of our duties going forwards. And there's always been a sort of implied duty to warn in any construction contract, but this is now mandated. So this is now set by the laws. It's absolutely essential that you understand that role. And then checking competency, which Hayley has already mentioned. Reasonable steps to check competency. So it doesn't say you have to prove that your subcontractors are competent, but if you get them to fill in the subcontractor competency checklist, then that counts as reasonable steps. And I think that's going to be a good way to administer that part. There's also some other duties and powers under the building safety legislation to do with obtaining consent, demonstrating compliance, notifying the client. If they ask you to do good materials or designs that don't comply with the building regulations, you have to let them know. So this verification role is part of the whole process the Building Safety Act introduced. And obviously, if you produce designs yourself, then they have to comply with the Act. So there's a couple of duty holders. There's the principal designer and there's the principal contractor. And we've now introduced these two quite comprehensive clauses, 1A and 1B, that deal with those two obligations. So I'm not going to read them out now because either you're familiar with it, or if not, you're going to have to sit down with new contracts and read them when it's relevant to what you're doing. So this is all language that you should be aware of, particularly if you've attended any of the Building Safety Act webinars or training, or looked at any of the articles online about it recently. So your clients also have some duties under the building safety legislation, and I suspect particularly for domestic clients they'll be less aware of this. So that's why we have spelt it out, and in fact we've put it before paying you. Now that might be a controversial position to put that obligation, but these are the obligations that your clients will have, and I think it's really important that you also kind of bring this up relatively soon when you're working with particularly domestic clients who probably have little idea that this is going to be part of their role. So it's really important that you help your clients to understand what their duties are. Clearly, if you're working with repeat developers, commercial clients, sophisticated clients, this will be water off a duck's back. They'll be aware of it, but there's no reason why we can't use a contract just to make it really clear, so we manage all the expectations of both parties as to what is required. So there was so much content about building safety. I didn't want to go through in a lot of detail because really you're going to need to sit down, work out what that means for you in running your business and on particular projects. But the next big changes I suppose we've made is in relation to the disputes mechanism. And we used to have a requirement to go to mediation, but we found less and less that members use mediation, because really negotiation and adjudication together provide a really good framework to avoid court proceedings as such. We've also put in a reference back to a building work guarantee, because if you've got that sort of cover on a project, generally speaking, you'll find that dealing with the staff at that insurance will be a much better way of, trying to resolve disputes. But realistically, we know that disputes are going to happen, and we need to have some form of structure for you to use. Adjudication may not always apply on domestic projects, but we've included it because it is a relatively fast, relatively low cost way of getting a decision. Now, I'm not going to talk about the quality of adjudication decisions, but generally speaking, my experience as a lawyer is moving on quickly, getting some sort of resolution is the best way to enable you to have the headspace to continue to do the excellent work that I know that you do on these projects. So that's kind of quite a rapid run through of the changes that we've made, but we wanted just to highlight what we've done so that you can see how the contract suite has changed in the last couple of years.
Just unmute myself. Thanks, Sarah. We have got a couple of questions in the chat here. First of all, Christian's asking if he can double check that the BSL Act does not apply in Wales at the moment. I have a question mark in my mind over that because I think most of it does apply in Wales. I think there's just some slightly different definitions of, for example, what a high risk building is. I think we might need to go away and consult on that, Sarah. Are you aware of anything different to what you just said?
I have the same I was under the same impression as you, Hayley. So I would have to say I couldn't say for sure, but we'll come back to you on that one.
Yeah. So thanks for raising that, Christian. We will double check on that. Yeah, and I had another question that arose from a meeting with some members earlier this morning, lots of whom were reporting that architects and designers don't seem to be very aware of their duties under the Building Safety Act. And so lots of designers are reluctant to sign off as a principal designer because they're not used to maybe signing things off in the same way that builders are because of getting work signed off by building control, etc. So I think maybe we might need to issue members with a piece of guidance that they can share with clients and with designers that they're working with, etc., that just sets out that fact that even if they don't sign off to say they're principal designer, they still are the principal designer if they produce the plans. So I don't know if you've got anything else to add to that, Sarah, but that seems to be the main issue that members are experiencing on the ground with regards to all of this.
Yes, and I think there's definitely a kind of worry within the sector as to who's going to be responsible for design and design sign-offs and stuff. And that's some of that is driven by insurances and insurers trying to kind of control what they might be responsible for if there was anything issue with the project. So I think there is a lot of disquiet as to, this is not business as normal, and therefore we don't quite understand it. So not quite sure what we should be doing, but also we don't want to have to tick a box to say, yes, we're happy with this design, because we've not had to do that before. So I think there is kind of a real nervousness in the sector. And I don't think there's a simple way around this at the moment. There's been lots and lots of articles written, webinars, all this kind of stuff, training to try and help people to understand what their roles are. But a lot of the contracts, and JCT is guilty of this, in their latest suite have gone very light touch without explaining what the precise roles of contractor, designer, contract administrator are in relation to the Act. And I think that's made it even worse because there's not the explicit list of duties that we've chosen to put in the FMB contracts. It's very much, well, we think you know what you were doing, but we know from CDM when it was introduced 20 years ago that it took the industry quite a while to kind of actually, jockey as to who was doing what and whether this was, a big change or not. And I think that's still where we're at the moment with the Building Safety Act.
Yeah, definitely. So Colin's asked a question that I'm not quite sure what he means, might need to clarify that, but is there a section under the revised contracts that identifies CDP elements?
So I think there is. I think now that's a good question, because I think we have a design element, and we say that the contractor can look at what design there is, and you kind of tick whether or not they're doing design. But I don't think we have a clear bit about that. But let me, if there's any other question, I'll go and have a quick look at the contract and see if I can.
Okay. The only other question that I had on my list was around liability periods, because I think, as you're saying, there is a lot of disquiet in our sector, and part of that is around increasing liability periods and members feeling worried that they're going to be held accountable for things that they did 30 years ago, and how are they going to deal with that issue. So my understanding is that the 30 years applies retrospectively, but that it's very unlikely to apply to a small building contractor working on a domestic or small commercial project. But I don't know, you might want to say a bit more about that, Sarah, about liability periods in general.
So we have kind of two now bits of legislation which kind of contradict one another. So we have the Limitation Act 1980, which basically said that if you sign a contract in a simple format, then you have 6 years liability for breach of contract. So if you breach the contract in any way, then a client can bring a claim against you for 6 years. If you've gone to the lengths of signing it as a deed, and if it is signed as a deed, it'll say so very clearly on the front of the contract that it is a deed, then the client can bring a claim against you for 12 years for breach of contract. We also now have the legislation which allows people who have a vested interest in a property which falls under the Building Safety Act to bring a claim for up to 15 years from completion. So what we've had is a lot of, again, jockeying to decide how we deal with that. Now, it could be that claims will be brought during the whole 15-year period, but the reality is that claims after 6 years are very difficult to prove because we don't have the documentation, the people who were involved in the project are no longer around, that the client may have sold the property and moved on. So even if there technically is a right to claim for 15 years after completion of the project, in practical terms, it becomes increasingly difficult to do so the further you are away from completion of the project. So we have seen in a lot of the other contracts and in the amendments that law firms are bringing out to their contracts, clauses saying your liability is 6 years except for claims for breach of the Building Safety Act, which will continue for the length set out by legislation. Now, the government could change that legislation and bring that 15-year period down. It's unlikely to do that just yet, but long term, it's still a possibility. So yes, technically under the legislation, there's a right to bring an action for 15 years after completion of the project. I don't think we need to get overly concerned about that because the reality is that stale claims at the moment are very hard to bring, very unlikely to be brought. The chances of a client bringing a claim under the contract for breach of the legislation is quite small. They're likely to just do it under the legislation itself. So yes, there is an issue. Insurers are looking at this, law firms are looking at this, developers are looking at this, but the practical reality is that late claims, stale claims are very difficult to bring. So, yes, there is still a technical period by which you might have a claim brought about you, but it's actually going to be difficult to bring in practice.
Okay, thanks, Sarah. There's another question in the chat here from Andre, who's asking about, well, it's a point really that he's making more than a question, saying that builders need to be careful about making alterations to design, in which case they may end up with the liability for the design if they've made amendments to it. So they should be getting them signed off by the principal designer, which I think is something, again, that some members are struggling with. Going back to the original design is not always that easy. And very often there's an additional cost involved because they don't want to sign that off for nothing. So
I think it's a really good point, and I think it's really important that you as members know what you're competent to do and what you're not competent to do. And if somebody says, can you check that this design still meets the client's brief, and you don't feel that you have that skill, say you don't have it, because it's there still. If that wasn't part of your obligation in the first place, and you have to be careful that you don't accidentally take on a design liability and then become a duty holder under the Act. So really, this demarcation of who's responsible for what is going to be quite difficult to navigate at the beginning, but I think will probably sort of in the next few years, it'll be much clearer. But in the meantime, don't accept responsibility for things and just be aware of that sort of, can you just check? We try and be polite and collaborate and cooperative, and we don't like to make a fuss and all that kind of stuff. But I think at this point, we're going to have to start being clear what our abilities are, what our duties are under the contracts, and what we think our role was. Because if our role was not to check those designs, then let's not check those designs.
It's difficult, isn't it? Because builders naturally tend to be problem solvers and want to get things done and get on with the work and not sort of pushing back on these kinds of issues. But that, as you say, is something to be really careful of. So Colin's asked another question. Is the contract suite able to be adapted to allow for phased completion alongside phased retention release? i.e., say the contract includes for 3 separate extensions to a school, where one may be completed 6 months prior with full use by the end user to full PC. Therefore, we'd like our first half retention released on each successful section completion. Wow, I don't think our contract.
No, and neither do JCT contracts allow for that.
Right. Okay.
So generally speaking, retention, and we don't really like retention. It's because actually, there's a big industry lobbying to try and get rid of retention, because it's effectively the client holding your money to ransom. A lot of clients don't know that they have to release it, won't release it, forget and spend it, so they don't even have it to give it back to you. So a final stage payment once the end of the defects period is kind of the way that the engineering sector has always dealt with this. And that's one of the things that we introduced at the request of members, because when we first amended this suite, I was, well, let's not put it in because it's not in your favour. But, we understand that some clients expect to see it, so we have put in a final stage payment instead of retention as such. So that basically means if you've done all the work, you get paid 90, whatever the percentage of the value is. And then once you finish the defects period, you get paid. Staged retention release is quite complicated to draft. It's very difficult to do. Most of the other contracts don't do it. So we haven't done it in these contracts either.
And most members probably wouldn't be working on a relatively complex project like that most of the time. So we've tried to make them applicable for most members most of the time. So, okay, hope that helps, Colin. And Gordon's asked whether the new contracts are available on the FMB website just yet. I think the web team are working on that as we speak. I just saw the web pages earlier, which are looking really good. There's lots of useful information on there for members. I think what we might do is send a follow-up email to everybody after the webinar with the link to those web pages when they are available, so that you can go on there and download the contracts for yourself and have a look at what's available. There are different versions for different scenarios, including there's a short form contract that is for projects where the building regs aren't applicable. So say something like an interior refurbishment or something like that. And then there are the slightly more more detailed project complex contracts that Sarah was just showing to us, which are the standard domestic contracts that most members use most of the time. And then there are commercial contracts as well. So there's quite a range for different scenarios, like with and without a retention or defect stage payment clause in there. So there's quite a range of different contracts for different kinds of scenarios. So do go on and have a look when we send you the link to the web page and see which one you'd like to use, which is most applicable for your project. And we're always interested in feedback from members. As Sarah said earlier, we won't be updating them every 5 minutes, but we do collate members' feedback and suggestions. And then the next time we review the contracts, we have a list of things that we'd like to incorporate next time around. So that would be really helpful if you give us that information. So I think we've pretty much covered everything. Just checking.
I just want to come back to Colin's question about the CDP. So contractor's design portion is where the contractor is doing a part of the design, not all of the design for the works. And actually on the front page of the simple building contract for domestic work, it basically says the work includes a significant design element by us, the builder, yes or no. So you can tick that. And then you'll need to describe that clearly in the works documents. It also then sets out the fact that the client is responsible for the designs they do, you're responsible for the designs you do. So in your works documents, that's where you're going to get the information as to what bits you're actually designing. So they need to be really clear. And we've tried not to use jargon that JCT use because not everyone understands it. I know everyone thinks the sector understands JCT jargon, but as someone who's trained builders, lawyers, consultants for 15 years, I can tell you that CDP is still misunderstood by lots of people. So we've tried not to use that sort of jargon, but there is a right for you to tick to say there is a significant element of design being done by the builder, which is what JCT would call a contractor's designed portion. And then the works documents, which you're responsible for and your client is responsible for, will explain which elements that you're actually doing the design for. And it's really, really important that if you don't want to take responsibility for design, you make that clear in your works documents. Because one of the things the works documents should do is not only say what you are doing, but should say really clearly what you're not doing, particularly in the light of competency requirements under the building safety legislation.
Thanks, Sarah. We've got another question here from Vance, who's asking about where he's doing a job, say minor plastering, the odd bit of carpentry and decoration. What do they do about the PD duty? Who would be the PD? I mean, I think it's to do with building regulations and whether building regulations apply to that work or not, isn't it? What would you say to that?
So I'm not a building regulations expert. So if building regulations don't apply, then you don't need to worry about it. But if they do, then you probably need to use one of the contracts.
And that's why we've got that short form contract on the website for that kind of job where building regulations don't apply, which is much, much shorter and doesn't have all the PC and PD duties in it. Okay, so Christian.
Christian's asking, is a works document what might be called the schedule of works? Yes, a works document is just a generic term meaning any document that describes the works. So, whether that's a specification, a schedule of work, a scope of work, all different terminology is used, which is why works documents is kind of my generic, something that describes what you're doing.
Yeah. And it does allow for that in the contract, doesn't it? By saying these are the documents that describe the work are referred to within the contract. So I think we've covered quite a lot of ground there. Your last chance to pop any questions into the box before we close the webinar, because I can't see anything else popping up. But like I said, we will send out a follow-up email to everybody, and I'm going to include that competence statement document because I'd really like feedback from members on that because it is a new document. And as soon as they go live on the website, we will let everybody know, and then you can start using them. And there again, let us know what you think. And hopefully they're going to be helpful. Like I said earlier, we put a lot of people have put a lot of work into these contracts, and the reason for that is because we know members really value the FMB contracts. It's one of our most used services, so I really hope that you'll make the most of those and be using them. So thank you very much, everybody. We'll close the webinar now. Thank you for attending. Thank you, Sarah, for all of your input, and have a great rest of the evening. Thanks, everybody.
Thank you.
Bye.